Hi, welcome to IP Somm. I'm Heather Boyd from Pillar IP, and my guest today is Linnell Horohooda from New Zealand, and she's a partner, and I'm going to say this with Kahui Legal, which is a Māori law firm in Wellington, New Zealand, which is in the North Island. And partner, you're going to correct me if I say this wrong. It's a Tumuake, right?
Yes.
Tumuake. So Linnell
Yes.
is a Tumuake at the law firm. So Linnell, why don't you tell us a little bit about your background and experience, please?
Kia ora koutou. Thanks, Heather, for the intro. And I guess I've worked in intellectual property for over 30 years, primarily at a large firm here in New Zealand, and recently shifted to the firm I'm at now, Kahui Legal, and with the aim of growing our intellectual property practice at this firm. Most of the work I did previously was international work and coming into New Zealand from overseas, with a small practice that focused on assisting Māori or Indigenous from New Zealand navigate the intellectual property system. So the goal with the shift is to focus just on the Indigenous practice and grow that and support our Indigenous businesses to explore intellectual property and protect their culture and cultural heritage in that space.
That's awesome. So just for people watching, Linnell is my oldest friend in IP. I met her probably, it was about, I want to say 2.5 weeks after 9/11. So in 20 years ago, we were at a conference. She was the first person in IP I met outside of my my own law firm that I was working at the time. Let's get back to talking about what your practice is, because this is fascinating to me. I know that Canada, we have Indigenous lawyers, but it's completely different from what you're doing. What you're trying to do with your law firm is to make sure that the entirety of the Maori people are protected through every aspect of law. Is that my understanding? And
Yes.
And not necessarily you personally, but the law firm that you're working for. So tell me what that's about.
Yeah, so Kahui Legal has been around for nearly 23 years or just over 23 years, and their primary focus has been on supporting Māori to achieve outcomes that support their aspirations. And part of the reason is that a lot of the laws in New Zealand have been to, I guess, what's the word I'm looking for, to support the colonisers coming into New Zealand and suppress Māori. So there's a lot of laws that have over time have not supported Māori, have been directly in conflict with Māori aspirations. And so therefore there is a lot of work to do to support Māori to achieve what they want to achieve. And so as a consequence of those issues, and these issues have been around for a long time, lands were stolen, and different laws are still being introduced that superimpose over Māori rights to their lands. And there is still a need for us to fight for those rights and to take those battles into the courtroom. So intellectual property is one of those spaces, and it's definitely a growing space and one that I'm very fortunate to be working in at the moment.
And I don't think that the issues that you're facing for the Māori people are unique coming from other countries. I mean, we have the same issues here in Canada with the Indigenous people, and I apologize. I don't even know if Inuit is an offensive. I don't think it is an offensive term, but it's the northern Indigenous people, and then the what we call the Native Indian or the Canadian Indigenous people. They've been facing the same type of issues, land appropriation. And then there's the Indian Act here in Canada, which they just reinforced it in 2014, which is disgusting. But it's all about making sure that it suppresses the Indigenous people's rights versus the rights of the colonizers, that they're overcoming. And this year's exhumation of over 5,000 Indigenous babies or children from the reservation schools or reserves, it's horrifying. And that's why I wanted to bring to light what you're doing, because I think that there's a place for that in Canada, and I'm sure there are. I just don't know of the law firms, but I know you and I know your voice, and I think that you're a really good person to express what it is that Indigenous people all over the world can do to protect themselves. So why don't we delve in a little bit more about what do you find from an Indigenous perspective? What is the meaning of cultural appropriation?
Yeah, so for me, cultural appropriation is, the use of aspects of another culture without real consideration about the origins of that aspect of culture, and using it also in a way that's inconsistent with those origins. So a lot of the time we see words that may have one meaning being used in relation to goods or services, but we as Māori and as Indigenous, we know these words have different meanings, and those different meanings mean that when you use that word in association with those goods or services, it's actually quite offensive. It's either it may be just inappropriate, or it may just be, in some cases it's been quite hilarious. So an example I'll give is in New Zealand, there was a company that used Horohooda, which means feathers, and also means adornments in one aspect, but it also means and refers to other hair and hair on the human body.
On the male genitalia, yes. We have the same thing here in Canada with a beer company calling it Horohooda.
Exactly, you did too. That's right.
Yeah.
Exactly. So that is quite. It's when it becomes quite funny, and so therefore that's just not appropriate. So there's a lot to be learnt from making sure that if you do choose to adopt a word or an image that you're not sure of the origins, to actually find out and make sure that you're doing it in an appropriate way. So
yeah, I wrote an article about the Horohooda, the beer here in Canada, where I said, doing a Google language search, or a Google translation search is not good enough. I mean,
that's right.
It just doesn't, because this beer company in Alberta honestly thought that it meant feather because their ale was light as a feather, and they were using New Zealand hops. So that's why they called it Horohooda. But everybody else who, once they found, it was a New Zealand man who pointed out to them that, what the true meaning could mean, or the slang meaning of Horohooda was. And a lot of people were saying, well, then it's the play on words. Canadian, we're like, up your beaver kind of thing, same kind of thing. But they don't realize the effect that can have on the New Zealand population, which is pretty substantial here in Canada, because we've got that reciprocity of living rights with New Zealand. So it really does come down to not necessarily how the colonizers, if I can call us that. I mean, it's not what I think. It's how it affects the people who, it's the origin of that. And that's what you're saying. Cultural appropriation isn't against appreciation. It's against things that either take money out of their pocket for what they've done the blood, sweat, and tears for, and or makes them feel offended in some way. So it's kind of like beauty's in the eye of the beholder. So is offense, right? So how do you measure that then?
And that's such a good point. It is in the eyes of the, you know, of the Indigenous people to decide whether it is appropriate or not. And that's, I guess, a big part of what Indigenous people are seeking is control to be able to make those decisions. And the intellectual property system in some ways takes that control away from them. And so that's the issue with the one of the big issues with the intellectual property system. Back to your point about the impact on Indigenous people back in New Zealand, the real impact is that the culture, the integrity of their culture is compromised. Right. And so this wonderful asset that we have, which is our Māori culture and our cultural heritage, becomes diminished because of this misuse and misappropriation. So it's maintaining that integrity, and it's not necessarily about, you know, putting it in a box and locking it away and stopping everybody from using it. We do want people to use it, but we just want people to use it in a culturally appropriate manner.
Or respectful.
Yeah.
Just respectful. I mean, that's the main thing. I remember watching, I mean, social media is the worst place, but also the best place for airing these type of grievances. I remember seeing I don't know if it was an ad or a photo of a white woman who had her hair done up like probably like an African queen kind of thing. You know, they cornrows and then piled high and everything. And I remember a comment that was put on there saying that this was cultural appropriation. And at that point, I'm thinking, could that not be interpreted as appreciation? Because I'm wearing, I don't know what it's called. This is
Pounamu.
Ponapu?
Pounamu.
Pounamu. So this is a jade icon, I guess. Describe this. What is this?
So we would call it a taonga, so a treasure.
Right.
A treasured possession. It's made from pounamu, so
okay. Like a shell type thing.
Yeah, so it's pounamu is a type of jade that's only found in New Zealand, and in particular in the South Island of New Zealand.
Right.
And so it becomes a symbol of a connection between you and I, because I gave you the gift, and it maintains that relationship between us, and you know, as friends. So it's more than just it can be given as a guardian to watch over somebody. It can be given you know, to celebrate somebody's success, you know, so it's a gift, or koha as we call it in Māori, but given as a treasure, a taonga, to symbolize our friendship and moving forward.
Right. But people can buy these when they go to New Zealand as well, because that's part of the tourist industry. So that would be cultural appreciation versus appropriation, because the Māori people are actually getting the benefit of either the financial reward for having made this in the sale of, or in the gift giving, it's that benefit of that long-lasting friendship. And it really truly is long-lasting friendship. So but then, so this hairstyle, the question then comes, well, who created the hairstyle kind of thing? Is it a appreciation if someone has someone from Namibia or wherever to create the hairstyle, or is it appropriation if they go to a high-end salon and pay for it? I don't think that there's, I mean, I think that's a completely world away from what we're talking about here. But I think that's what the crazy world is, that people want to identify what is appropriation and what's appreciation. And I think you've said it best. It's mostly about the indigenous people, and it's whether the respect is given there.
And that's, you're right. We have seen a lot of social media about people doing, in particular, the cornrows and the braids, and a number of celebrities have been called out for, incorporating those hairstyles into their public, as part of their public persona. And it is interesting because that has been happening for a long time, and was accepted for a long time without any backlash towards celebrities, but all of a sudden it has become inappropriate. And I don't know the history of cornrows and braids, or where they come from, so I couldn't speak to that issue directly in terms of whether it is appropriate or not, but I'm interested to follow and see where it lands.
Exactly.
Because
me as well. So let's go back to talking about Māori people, because I love you people. They're fascinating, beautiful culture, very, very organic culture, right? Everything is about the land and the earth. And I think that's true of most indigenous people. It's all, they're not steeped in the Catholic or whatever religion. It's more based on what they can get from the earth and what they can give back to the earth. And I think we can all learn from that 100%. So let's talk a little bit about how you can help Māori, which would probably translate into how indigenous people themselves can help themselves to make sure that their rights are being respected.
Yeah, there's a number of steps that Indigenous people can take around the world. I think first and foremost is identifying what is the parts of your culture that are most sacred, and perhaps the parts that are less sacred. And the reason I say that is because you need to be able to focus your efforts in the areas that are most important, and identifying that those areas of primary concern is critical to ensure you can take some positive steps in the right direction. So if you can, I think putting first and foremost, identifying and then putting in place some ideas about what is appropriate and what is not appropriate in relation to those aspects of culture that are important to you, and then also the ones that are less important. And if you can do that, then that places you in a position where you've set the framework that you're willing to accept in, this busy world that we live in. The next step, I think, is actually to then think about what protection can you get. So can you actually get some registered IP protection? I acknowledge that intellectual property does not provide the ideal protection. That's well accepted. The IP framework is not a place that will protect the integrity of the culture and heritage, but it will protect aspects of it. And so there are some value in protecting IP, protecting those that heritage through intellectual property.
Right.
And so explore those opportunities as well. And so then
maybe we can touch on what types of aspects of IP. Sorry, my dog is playing with the pit of a peach that my husband left. So, all right.
Having fun.
So maybe we can talk a little bit about what types of IP may be appropriate for helping Indigenous, Māori, whomever, perhaps worldwide, because we're all, IP is kind of the same almost everywhere. So what types of IP should they consider protecting, and is there anything that you can think of that would be a trigger to protecting that?
Yeah, so I mean, I guess trademarks are probably the most obvious choice because you can protect names, logos, images,
Words.
and named words. Those aspects are probably the most easiest, and trademarks can last forever, assuming you continually renew them. And that's probably the most cost-effective tool that we have available.
Yeah.
And you can protect a wide range of animations and 3D marks, and you can find lots of different types of marks to protect in as a trademark. The other rights are also important. So copyright, designs, and patents are all also valid, but the issue with those is it has to be new, right? It has to be a new creative work. So for contemporary works, those are ideal places to go as well. And then lastly, there's of course GI, geographical indications, which provide a forum for Indigenous cultures to protect traditions that they have built up over a long period of time, which generates a product that has certain characteristics. And so therefore, there's aspects that you can protect as GIs.
Can you give us any examples of Māori GIs that not necessarily that you've protected, but that could be protected or that are protected?
So for New Zealand only currently has a geographical indication framework for wines and spirits. So it's pretty limited in terms of what GIs are registered here. The only ones that are, or the primary ones that are wine. So Marlborough, as we talked about earlier, is registered for as a geographical indication for wine from Marlborough. Right. Central Otago.
Is Martinborough also?
Yes, Martinborough, Gisborne. So there's not any Māori aspects registered as geographical indications yet in New Zealand.
What's the dance that the
haka?
The haka. Why can't that be protected through geographic indication? And it should be protected worldwide.
Yeah, it does need to be protected worldwide because it's misused everywhere, isn't it? But the thing with our current geographical indications framework is it is geographical names. So, and I mean, we are in negotiations with Europe for a new free trade agreement. One of the conditions of that free trade agreement imposed by Europe is to expand our GI regime to include food products, because food, that's really important.
Europe just expanded that about 5 or 6 years ago. So Italy has been the predominant filer of that, with all the Parma ham and Parma cheese and everything. So
exactly.
Yeah. But one would think that performances like the haka should be protected by copyright, perhaps. Yeah, but is anyone enforcing that? That's,
In relation to the haka, I mean, the haka was written, more than 50 years ago. So any copyright that existed has since expired. And that is kind of one of the limitations of the intellectual property framework, is that it does have these expiry periods, which for Indigenous people are just not appropriate. For Indigenous people, their rights never expire. Their cultural relationships with their cultural heritage are passed down from generation to generation, and so it's it's consistent and enduring. And that is one of the huge limitations with the IP framework.
So let me ask you this: when you're filing for protection in Māori, is it possible to is Māori a legal entity? Right? That's the question. And if you could form a legal entity for the Māori people, then you could potentially protect the haka as a copyright performance, that's owned by the Māori people, that only
Mm,
Māori people can perform it. And they should be the only people performing it. Let's face it. I mean, nobody else should be able to perform this.
yeah, there is no one a group called that represents all Māori, and that's because we have individual tribes or iwi and even sub-tribes called hapu that were the sort of the English word for it? I'm trying to think of the English word for it. But they regulated
the governing council kind of thing.
Yeah. So they regulated society. Yeah. So they were sub-tribes and they regulated their communities, and there was a lot of little communities across the country. And so having one Māori entity would require there to be one person from each of those sub-tribes involved. And that's quite a
form of government.
Well, yes.
Why can't they do that and then work in concert with the New Zealand government? I mean, I'm just maybe blowing smoke up my whatever, but that's the way everything should be going in that direction, is that you have a say in the government of New Zealand because you were there first.
And I mean, that's one of the ongoing issues that Māori and Indigenous peoples face around the world. We weren't, our friends across the ditch, sorry, I shouldn't say across the Tasman Sea in Australia. Yeah, we call it the ditch, the Tasman Sea in Australia. The Aboriginal people of Australia have the same issues. Native
Canada.
So
they're not considered an entity of themselves. They're all these disparaging little groups that the government of Canada comes down and says, well, we want to control you instead of working in concert with them. I think the world would be a lot happier place if there was more compatibility in that respect.
That's so true, and that's hopefully that's one of the aspirations of Māori, to sit alongside our treaty partner, because we signed the Te Tiriti o Waitangi, or the Treaty of Waitangi, to enable
can you say those again?
The Treaty of Waitangi.
Okay.
Waitangi, and in Te Reo Māori it's Te Tiriti o Waitangi. And that is one of the founding documents of New Zealand that enabled, the English to settle here, and that sets up a partnership structure that was envisaged by Māori, but which hasn't realised. And so that's one of the areas, around government and control. And for Māori, it's called tino rangatiratanga. So being able to control our own destinies, and that's a huge issue across the country for all Māori still.
So I know that you were part of when you were with the old firm, and I'm assuming moving forward you're going to do the same thing, is be part of the International Trademark Association, which is referred to as INTA. And you did a lot of speaking on Māori issues and incorporating IP, particularly trademarks, into the Madrid Protocol. You were on the Madrid committee, were you not? And how you can maybe integrate Māori into those type of organizations, kind of thing, so that there's some protection. And I'm thinking that you're the best person I know to speak to these kind of issues about how to train people in other countries to stand up for Indigenous rights in those various countries as well.
Thank you for that. I am currently the chair of the Indigenous Rights Committee for the International Trademark Association, INTA. I am also on the presidential task force for diversity, equity, and inclusivity for this 12 months, which is also, I'm on that task force to help explain the issues for Indigenous peoples in the space of intellectual property. And whilst that task force is focused on improving diversity within the within the association, the lens I have been bringing is how do we think about in terms of policy, what that actually means if we want to be diverse and inclusive, how do we reflect that also in our policy that INTA has. So, and that's part of the teaching aspect that you mentioned. And, that's been a really interesting journey. I love telling the story of Indigenous peoples because it does relate to, everybody relates to the story, they understand the issues. The thing is, the problem is that the frameworks we are working with don't allow for the recognition and appreciation and celebration of our culture and ensuring its protection at the same time. So there's a lot of work to do. There's a lot of work being done around the world, don't get me wrong. At WIPO, the World Intellectual Property Office, they are doing a lot of work there and have been for many years. Other countries have developed new sui generis legislation to address this issue. And it's great to see, and it'll be interesting to see where New Zealand ends up as well, because we're still on that journey, and as are other countries.
Are you working on a Māori Indigenous Act, I guess, or something, a Māori Act, I'm going to preface this by saying that here in Canada, we have something called the Canadian Olympic Act. And that protects all IP that the Canadian Olympic Committee comes up with for athletes relating to Olympics or whatever. And then those are protected under official marks, and nobody can adopt them ever. And, under fear of death or dismemberment or something, probably not. But so I'm wondering if Indigenous cultures, I guess, in various countries could create those type of policies or acts or legislation that would protect the culture. I mean, it just makes sense to do something like that. And
it so makes sense. And I think that's, that's what we're looking for in terms of a framework. And the issue is it does require an element of giving up of control. And I think that's the main area where the
government's everywhere. It's a problem.
They get scared, and there's it's just an element of control and an element of and uncertainty. It's kind of like, well, how are we going to do this? And you're right. In New Zealand, we have a similar our Flags, Names and Emblems Act that protects the Olympic.
So why can't they do that for the Indigenous people in the country? I mean, then there wouldn't be any question about having a football team called the Edmonton Eskimos in Canada or the Washington Redskins. I mean, that it would eliminate that kind of stuff. It would be in black and white. Here are the terms you can't use to name or whatever, unless you get consent from the Maori people or this organization that overruns that kind of thing. It just, that to me makes sense, but I'm not a policymaker, so I don't know how to go about that. So let me go back to you and your new partnership with this new company, this new law firm, Kahui. Oh, okay. Hui is a type of beer in New Zealand I was familiar with when I went. How are you helping clients? Like, what is your focus, and can that translate to international work?
Yeah, so I guess my immediate goal is obviously to assist navigate the intellectual property system. So there's a, for commercial undertakings, supporting Māori Indigenous undertakings to protect their IP.
Yeah.
The other area is actually building up those that I want to do more of, is work with Māori around developing what their protocols are, or their, the terms and conditions, I can say, of the use of their cultural heritage, what they will accept and what they won't accept.
Right.
And helping build up that sort of framework to create some certainty for others, but also create some certainty for Māori in particular, because they can then know what to focus on and focus their efforts on, and then they can build up, I guess, in my view, their own commercial undertakings under their own terms at the time that's right for them, and use it in a way that's consistent with their culture, and their, we call it tikanga customs.
Okay.
So adopted in an appropriate way. So that's my goal. And if we look at Māori people in New Zealand, we are at the bad end of all the statistics that possibly exist. And in my view, if we can build up economic activity within those communities, then that's a way to help turn around some of those other statistics by giving people a job, helping educate in different spaces, connection to culture and heritage, and creating these little economies that work for our people, in my view, is where I'd like to get to.
So basically what you're saying is you're starting the foundation of an act that would protect all Maori people. Like the Canadian Olympic Act, or Canadian Olympic Act, or Paralympic. What is it? Canadian Olympic and Paralympic Act, something like that. Because it really does spell out all the framework of what protections they have, but it also lists all the IP that nobody else can adopt. And that sounds to me like, you could include the haka in there, you can include artwork. And you don't have to worry about, and I think because the Canadian Olympic Committee didn't start way back in the first Olympics when the COC was created, they had to create an act that would protect all the previous years and stuff, so that they were the only ones who were making money off it, because they give money to athletes, and I get it. But once you give an organization enough power, and this is where you run into problems with the government maybe saying, whoa, because we don't know what we want to give you here. Because if you have that type of power, there's oftentimes there's, I don't want to say abuse, but there's overstretching. And that's the thing, is once you give some control, you have to make sure that it can't be withdrawn, kind of thing. So there's so much that you can work with, and I know that there's so many hurdles ahead of you, but I'm in your corner.
Awesome.
Yes, cheers. Oh
yeah, cheers to that.
I've been drinking all along, but okay, so how do you say thank you and goodbye in Māori?
So I guess we would say hi, thank you is ngā mihi. Ngā mihi, and goodbye is haere.
Haidera. Now, does that mean goodbye or until the next time? Is there a different?
And until the next time is mā te wā. That's probably easier.
Mā te wā. I like that one. Mā te wā.
Yeah.
All right. Thank you so much, Linnell. I can't thank you enough for this. We're going to put your contact particulars below. So if anybody is looking for someone to talk about Indigenous law, particularly in New Zealand, but I'm pretty sure that based on your understanding of IP rights throughout the world, that you've been doing this for 30 years, you'd be a good person to reach out to for any Indigenous anywhere in the world.
Thank you.
As a final New Zealand cheers, how do you say cheers in New Zealand? Isn't it?
Oh, I actually don't know what the cheers is.
I remember
we say cheers.
Thanks so much. If you like what you saw here, please like, share, comment below, and subscribe to our YouTube channel. Remember, we're not giving legal advice here. We're just sipping some wine and talking IP. Cheers, Linnell. Thank you.
Cheers.